Good morning, friends. My dear friends and fellow citizens, today I am before you to speak on a subject which is central to the survival of constitutional democracy: judicial independence, social diversity, and constitutional morality, a call to defend the last guardian of democracy, safeguarding the constitution in challenging times. My friends, the judiciary is often described as the last hope of the citizen. When governments violate rights, citizens approach the courts. When constitutional values are threatened, citizens approach courts. When power becomes arbitrary, citizens approach courts. Therefore, the credibility of the judiciary is not merely a judicial concern, it is a democratic necessity. Today, concerns are increasingly being expressed regarding the judicial appointments, judicial elevations, post-retirement appointments, ideological influences, and continuing absence of social diversity within the constitutional courts, that is, higher judiciary. These concerns deserve serious discussion. The Constitution created a system of checks and balances. No institution is intended to dominate another. The judiciary was expected to remain independent of both political power and public pressure. But public confidence depends not merely upon the actual independence, it depends equally upon perceived independence. Former Union Minister Arun Jaitley, ironically, who was the BJP leader, once cautioned that pre-retirement judgments may be influenced by post-retirement opportunities or appointments. Whether one agrees with the statement or not, it highlights an institutional concern that deserves reflection. Recent years have witnessed several instances where judges accepted important governmental assignments of retirement for their judgments which were given before retirement. Likewise, debates have arisen regarding judicial elevations following judgments delivered in politically significant cases. I am not here to question the integrity of any individual judge, my friends. That would be unfair and inappropriate. My concern is institutional. The Constitution demands systems that eliminate even the appearance of executive influence or governmental influence. Another issue requiring urgent attention is the social diversity. India is a civilization of immense diversity, yet our higher judiciary often fails to adequately reflect the social diversity of this nation. Women remain underrepresented. Scheduled caste people remain underrepresented. Scheduled tribes people remain underrepresented in higher judiciary. Then OBCs remain underrepresented. Minorities remain underrepresented. Official data placed before the parliament by central government itself in the month of February 2026 reveals that nearly 3/4 of the High Court judges are from appointed in recent years belong to general or upper caste category. Number of High Court judges appointed between 2026, 21 and 26, for example, are 593 judges, High Court judges were appointed. Then among these 593 judges from SC category, only 26, that is 4.38%. Judges from ST category, only 14, that is 2.36%. Then judges from minority category, 37, 6.23%. Judges from other backward classes category, 80, that is 13.49%. But judges from upper caste, 436, that is 73.52%. And then with the latest appointment of 5 judges to the Supreme Court, the representation of the general category has risen. The current demographic breakdown among 37 sitting judges of the Supreme Court, one post is vacant, is that the general category, that is upper caste, 33 to 34 judges, 90%. Scheduled caste judges, only 2. Then other backward classes, only 1 judge. Then women judges, 2 judges. Then minorities, 2 judges. Scheduled tribes, nil. A judiciary representing only A narrow social spectrum cannot fully appreciate the lived realities of every citizen. Diversity is not a charity. Diversity enriches constitutional interpretation. Diversity strengthens justice. Diversity enhances legitimacy. Most importantly, the oath taken by every judge is to the Constitution, not to the governments, not to political parties, not to ideologies. The Constitution expects judges to defend liberty, equality, fraternity, secularism, federalism, and social justice. Sometimes this requires courage. Sometimes it requires standing against majoritarian pressures. Sometimes it requires standing against the governments. That is precisely why judicial independence matters. As members of the legal fraternity, we the lawyers, we must therefore advocate transparency in appointments, greater accountability, social diversity, cooling of periods for post-retirement appointments, protection from executive influence, strengthening constitutional morality. My friends, the father of Indian Constitution, Baba Sahib Dr. B.R. Ambedkar, warned us that the constitutional morality is not a natural sentiment. It must be cultivated. Today, perhaps more than ever, India needs judges guided by constitutional morality rather than ideological conformity, constitutional courage rather than institutional convenience, and constitutional values rather than political expediency. If the judiciary remains independent, democracy survives. If the judiciary becomes dependent, democracy becomes vulnerable. The future of constitutional governance in India depends upon preserving that judicial independence. The Constitution did not create the judiciary to be a partner of executive nor an adversary of the executive. It created the judiciary to be the guardian of the Constitution. Whenever judicial independence weakens, constitutional rights weaken. Whenever social diversity is excluded, constitutional justice becomes incomplete. The future of Indian democracy, therefore, depends not merely on who governs, but on whether courts remain fearless enough to tell those who govern that the constitutional limits still matter. Thank you, my friend. Jai Bharat, Jai Constitution.